Welcome back to Open Line, talking with elder law attorney Tim Takis. All kinds of interesting questions tonight. Essentially, the overarching topic, what do you do to help care for an aging loved one or to prepare for yourself as you get older, financially, the cost of nursing home care, wills, trusts, all of that. And let's go now to Melvin. Hello, Melvin.
Yes.
Go right ahead.
Excuse me. My name is Melvin, and I sold a house this year. And the first house I ever sold, I've been in real estate for quite a while, but I never sold a house before. And I just want to know, I'm 80 years old, I want to know what is that, is the capital gain situation is. Is it an age situation, age of the house, age of what? Give me some information on capital gain, because I never sold a house before.
Right.
Bought a lot of houses, but I don't know nothing about selling a house.
How long have you had this house that you just sold?
Probably 30, 35 years. Probably.
So Melvin, have you been living in the house?
Nope. I rented. It's always been a rental property.
Okay. All right. So that tells me a lot.
Okay.
For one is that if it's not his homestead, there is no capital gains exclusion for the homestead. And we talked about that earlier in the show, where people buy and sell real estate. But for most people, probably the great majority of this country, when they buy real estate, their big purchase is a home. And then at some point when they sell and they move, they've got cash. And now is there a capital gain? The difference between what they bought it for and what they sold it for is the capital gain.
Right.
So that's the key thing there for Melvin. Okay, he's owned that property for 30-some years. He bought it whenever, 1980 or whatever, and for maybe $30,000 or whatever, and now he's selling it for $200,000, and so because it's not his homestead, he has a $160,000 cap. He bought it for whatever the difference is between what he sold it for and what he bought it for.
Basically his profit, which in this case is huge.
Right, it's huge. Now, maybe if he puts some improvements in it or whatever, that can increase the tax basis, but putting a new roof on, putting maintenance and repairs don't increase the tax basis. So as a general rule, it's going to be what he paid for it, and that's his capital gain. And if it's capital gain, is like you said, it's like, let's say it's $180,000, then in my view, if you're looking at a capital gain like of that size, then it's worth talking to an accountant or other tax expert to see, all right, how should I structure this in a different way? Do I really want to get $180,000 or whatever? Sounds great, but when you got to pay maybe 20% of that out as taxes, you might go, well, is there a way to stretch that out over more than 1 year, more than one tax year? Did you have a lot of taxable income this year? Should you wait until next year? When your income is not as much? All those sorts of things that come into play.
And his question also, he said he was 80 years old.
80 years old. No,
it doesn't matter your age here.
Yeah, doesn't matter. Doesn't affect his Social Security. Mm-hmm. Now, it may be, well, I shouldn't say it doesn't affect, but it may be his Social Security might be taxable because now he's got taxable income.
Right.
Because now Social Security benefits being taxed, it may affect, his, again, that's one of those things that's really when he needs to sit down with somebody. That if he's been in the business of buying property and whatnot all this time, maybe, and he's now looking at selling, now it's time to get somebody to get professional advice, Melvin.
And that's only with a rental property or some non-homestead. Yeah. So if you've lived in a home for 30 years, totally different story.
So think about this, and I know we have another caller, but okay, if you're buying a piece of rental property, and has he been depreciating it? Has he been taking depreciation on the house on his taxes? And now he sells the property. There are rules about recapturing that depreciation and all those other things. So it can get complicated. In addition to being costly.
I bet. All right, we were also talking about wills before. Mm-hmm. How many problems do you see pertaining to wills?
All right,
this is one of the most contentious areas, I bet.
biggest problem that I see, at least in my practice and what I do, is I see people doing wills and basically leaving an asset from one spouse to assets from one spouse to another, and thinking that that's okay. And maybe in cases that it is, like for instance, the case that I had this afternoon that I was talking about earlier. Husband has had a stroke. You know, he's had a couple of heart attacks. He's kind of getting feeble. His wife is in good health. Well, if she dies first and she has a will that leaves everything to him, then what is he going to do with the assets if he winds up going into a nursing home?
He would spend them all, right? It would go toward his nursing home.
Right.
Right.
That's what would happen. But what if the wife said, well, is there a way for me to set up a trust for those assets, so if I predecease my husband, you know, then those assets can go into a trust for him. And actually there are ways to do that, you know, and their federal law provides for how to do that in the right way, so that, you know, let's say that the husband, say in the future, whatever would go into the nursing home, then the state or the nursing home can't get those assets. You know, and that's an important thing that I think a lot of spouses don't realize, or what they think of is that, well, my husband's got Alzheimer's disease, so I need to do something. You know, so I don't know what to do, so in my will I'll leave everything to our kids. Well, that's not a good idea.
Right.
Because for one is that you've disinherited your spouse, and then, you know, the spouse is entitled to a widow's share. And then second is that the likelihood is that you're still holding the assets jointly as husband and wife. So you're disinheriting your spouse doesn't mean anything because you're holding assets jointly as husband and wife anyway. So you die and everything is going to him, you know, by the way the assets are titled. So you've accomplished nothing. You know, that's the biggest mistake I see is people.
That's a big mistake. Yeah.
You know, not thinking about what the possibilities are if I die. What are the possibilities of my leaving assets to this person?
That's all right. Interesting. All right, let's go to Sherry. Hello, Sherry.
Yes, hi, good evening.
Go right ahead.
What I am interested in knowing is whether or not a trust or a living trust or something will protect your money. Say if you have one, and can you draw on a living trust, and will it protect your money from, you know, a variety of things?
Okay.
Well, if you transfer, for one, if you do what we would call a garden variety revocable living trust, which in other words, what that means is that you have a house and you got money in the bank and you say, okay, I'm going to create a trust that's revocable, which means you can always get the assets back. If you can get the assets back, then your creditors can. So you don't have any, so that's not asset protection.
Okay.
All right. It may be probate avoidance because at your death, your trust document says, when I pass away, I want my trustee of my trust to distribute my assets to my children, so those pass outside of probate. That's why we do that.
Right.
But it's not asset protection for you.
Okay.
Now, there are certain types of trusts that you can create during your lifetime that will have asset protection. There's one called the Tennessee Investment Services Trust. That's kind of like an estate planning asset protection tool, which really is not really pertinent in our area, because the rule there is that they have a lot of different rules, and that's one of those where your estate tax expert comes in because they don't work in our area. They don't give us asset protection from the nursing home, you know, or because the assets are still available to you. Because if the assets are still legally available to you, they are available to the nursing home, and they are available to the VA. You know, now, maybe like in a Tennessee Investment Services Trust, they may not be available to your creditors, but there are limitations and conditions on that, and you've got all those sorts of things. So that's kind of, I hate to use the lawyer's answer, which is it depends. You know, but I've often said, maybe on this program, but elsewhere, is one of the things about trust, it's a wonderful product of the human mind. I mean, about, you know, saying, well, how can we have assets that we hold for somebody else?
Right.
Maybe a minor, a disabled person. You know, I mean, there are a lot of reasons why that they're very useful. but it all depends upon what is it that you're trying to do. What are you trying to accomplish? And will a trust, like a tool, will it accomplish that? Is it the tool to accomplish what you want?
You probably see people, and we only have a few seconds left here, but you probably see people that get trusts and maybe they don't need them.
Yeah.
You see
We
that
do.
messed up.
We do that. Yeah, we see that. They come in, they think they got a revocable trust, and they do, but they haven't put anything in it, so it doesn't avoid probate. You know, so a lot of that stuff happens. Which is, sometimes I think the AARP has said is revocable trusts are sold; they're not bought.
So
For the average lawyer,
go to
or
an
the average
expert.
person, think, oh, everybody needs a revocable trust.
Right.
I mean, it was a big.
I see what you mean
It
there,
rolls
yeah.
around every few years. Oh, yeah, you need a revocable trust, and then, somebody's running ads in the newspaper. Come and get a revocable trust, and they're told all kinds of neat things about how it works.
All right, we have to take a break. We're going to
Go
come
ahead.
back. We're going to wrap everything up. Put your information out there if you have a question. We will take a break. Be back right after this.